Hi, good afternoon, everybody. This is attorney Kathleen Scott, and I am here today to talk to you about workplace speech in the time of Dobbs. First, let's start our presentation off with a quick apology. I was intending to be making this presentation to you from my comfort of my office, but due to some travel delays, I'm doing so in the airport. So let me apologize in advance for any issues or discomfort that might be heard in the background from background noise. I'm going to go ahead and share my screen. Hopefully everyone can see that. And we'll get started on Dobbs workplace speech. So one of the things I hope to accomplish today is really just to put some ideas in everyone's head in terms of how to conduct themselves now that we have this sort of bombshell Supreme Court opinion and how it really has become sort of the talk of the town in the workplace and the subject of many water cooler conversations. Hopefully give everyone some good practical advice. Okay, so one of the best things I can tell you is to look at, first of all, a lot of people have beliefs about the way things should be in the workplace. Well, I can't be fired for that, or I can terminate an employee for that. It's important to make sure that those beliefs are well-founded and that they are supported by the law and they're not simple knee-jerk understandings, because doing that might be very costly. So you might think you have certain rights, but let's be certain about them. And here are some that I think are helpful for you to know. Number one, myth number one, I should call it, there is no expectation of privacy in the workplace. So a lot of times people tell me that violates, Kathleen, that violates my workplace privacy rights. In fact, you don't have workplace privacy rights here in the state of Florida. And that's true for private employees. It's a little bit different with public employees, but the scope of today's presentation is going to be focusing on private employees in the workplace. So those emails that you send in the workplace, conversations that you might have that get overheard by others, those aren't private. If you have a workplace locker, your locker could be searched. If you keep things in your desk could be searched. If you have a work computer and you store personal items on that computer or personal information, that may not be private. That doesn't mean that your employer can use your social security number for improper or nefarious purposes. What it does mean, if you by chance are writing an email to a friend about how much you hate your job, that is not going to be held to be private. That is going to be something the employer has a right to look at because it's their property that you're using. Where it gets a little scary too is if you use a cell phone or another device or tablet and you connect to your employer's Wi-Fi, sometimes some of the information can be retained. That has been held in Florida courts to be the employer's property as well. So scary stuff. If you're an employee, what's the takeaway? Don't talk about private things in the workplace. Big no-no. All right, let's talk about a second kind of a myth I've been hearing lately, especially now that we're approaching midterm elections and we're approaching some of the most contentious times that we've lived through. There is, switch this page, it is illegal to talk politics in the workplace. No, in fact, it's not at all illegal to talk politics in the workplace. And again, private employment, it's different with public employers. But the First Amendment only prevents the government, not your employer, the government, from abridging your freedoms, like your right to free press or religion, have an opinion. We hear people talk a lot about their First Amendment rights. You really don't have those in a private workplace. And they certainly don't prevent your employer or your coworkers from talking about politics in the workplace. But there are limitations. We'll get to that. How about your political beliefs? We're living at a time where there's sort of their camp and this camp, and those camps aren't really communicating. And the culture of a workplace might even be dominated by a particular political mindset. So what about, can you be fired for your particular political beliefs? So Florida is an at-will state. And what that means is it doesn't really recognize political affiliation in the private setting as a protected characteristic. So there is some prohibitions. You can't be encouraged or discouraged from voting, and you can't be coerced into voting for a particular political party. So if workplace politics talk sort of goes into encouraging you to vote one way or the other, that may be improper. But just straight up political discussions, completely okay in the workplace in today's Florida, under Florida law. How about, why is that? People say, well, and I'll explain, in an at-will workplace, you can be terminated for any reason, a bad reason, a good reason, or no reason at all. You can't be terminated based on a protected characteristic, and there are only a handful of protected characteristics. Put them up for you so you can have a look. And the common ones you probably know: age, race, gender, sex, that type of thing. Those are the common characteristics. And so notice political affiliation isn't on there. What is on there is religion. We're going to get to that when we talk about the recent Supreme Court opinion in Dobbs and how that might change this. What about conversations in the workplace? Can you discipline an employee for their speech? Very, very complicated question. So of course the answer is very lawyerly. It depends. We're going to walk through some examples of that. But in answering those questions, so we've covered there is no workplace right of privacy in the workplace. We've discussed that. We've discussed that that political beliefs are not a protected characteristic for private employees. So now we're talking about how can you restrict or govern workplace speech in the workplace. And well, the one big statute we have to look at is a federal law. It's called the National Labor Relations Act, and it's enforced by the National Labor Relations Board. And so what it says is that if you're in a workplace and 2 or more people join together to change the terms and conditions of their employment, that's protected activity, and an employer cannot discipline them, terminate them, or take an adverse action against them if people are doing those things. Just to break it down, the NLRB enforces law for union workplaces and non-union workplaces alike. I should have put this up as another myth, but a lot of times people think, oh, the National Labor Relations Act, that only applies to unions and employers with unions. That's actually not true. And so I want to be clear about that. So getting back to how does that apply the NLRB with communications? Well, in the day of social media, you might have an employee post, even off duty, hey, this thought or belief about politics or religion, this thought or belief about workplace rights, or whether a woman has a right to an abortion, or whether the employer should cover that under their plan. Now, if another employee likes that social media post, or other employees join in the conversation, that might be concerted protected activity. And so that is something that we want to talk about when we think about these Dobbs conversations that are happening in the workplace. So while generally speaking, politics is something you can discuss, when it goes further and employees are kind of joined together to talk about how it affects the workplace, that's going to be concerted protected activity. So that's protected conduct, and an employer can't terminate or regulate that type of speech. Let's talk about some real concrete examples. The health insurance one is probably the best one. So it's a lot of conversations are happening about people who might need employees who might need to leave the state to get certain medical protections now in the wake of the Dobbs case. And so that if employees are talking about that, I would argue that is protected speech, and you can't prevent them from doing that if you're the employer. And you can't prevent them from talking about it on their social media. So current events can have the same effect, right? So if, for example, there's a recent opinion like the Dobbs opinion that are talking about a woman's rights and how women are treated in the workplace, if someone's liking those posts or talking about those types of posts in the context of the workplace, be very careful and tread very lightly. It gets even trickier because when we talk about whether a woman has a right to choose and their reproductive rights, it inherently is going to invoke a conversation about a religious belief. So there are those who are going to say that they feel like their religious beliefs are being infringed by talking about helping people get medical care. And there's going to be those on the other side of the spectrum that say something different. So what do you do if you're an employer about those conversations? And I'm going to give you some do's and don'ts, and they're not very bright line. And so I'm just going to warn you, I wish I was able to give a more clear perspective, but we're living in a time where things are changing. So let's talk about the Dobbs opinion. So Dobbs, we know, overturned Roe v. Wade, and that was an opinion where it constitutionalized a woman's right to choose to have an abortion. That's now probably one of the most hot ticket items, current issues in the workplace. And I feel like we're going to cross into some dangerous territory when we talk about Dobbs in the workplace setting, because like I said, on one hand, you're going to have people with deeply held religious beliefs. They might even be starting to share stories. On the other hand, you're going to have others who might have their own personal experiences about things. These are all being shared into the workplace, and inevitably they're going to delve and dive into this emotional topic and religious discussions. And so employers have to be really mindful about that. So it's not enough to just say there will be no discussion of religion in the workplace. Really doesn't work, because if employees want to talk about this healthcare aspect of Dobbs, or talk about how their rights might be infected, you can't really prohibit that per se, right? On the other hand, you can't discipline an employee either for talking about those things. So that's going to be an important consideration. So here are my sort of do's and don'ts. As an employee, yes, you have a right, not a right, you can, I'm not going to call it a right, you can express your religious beliefs in the workplace. You cannot try to encourage others or make others feel pressured. Or if you're the employer, you can't create a culture where only people who share your religious beliefs are going to be promoted up through the organization. So while there's some limited ability to talk about religion in the workplace, it can't go so far as to cross the line over into creating a culture where people who don't share their beliefs are unwelcome or don't have the same opportunities. You can absolutely discuss current events in the workplace, for sure. And there's nothing wrong with that. But where those current events start to cross that line into political speech, employers can say no political speech in the office. Employers can also say, we're going to allow political speech in the office, in the break rooms, as long as it's not disruptive, as long as it doesn't interfere with the workplace, that's fine. But here's a good tip for employers. This is a great time to look at your workplace and say, am I using objective criteria when I make decisions about pay, when I make decisions about promotional opportunities and hiring decisions? Am I using an objective criteria that doesn't necessarily mean that I'm creating a culture where I only hire people who are just like me, believe the same things I believe in, look just like me, and share my religious or political beliefs? Because you don't want to create a culture of just like-minded folks, because what that does is that invites discrimination claims, that invites these types of claims. It creates a workplace, frankly, that doesn't benefit from diversity. And all the studies show that the more diverse the workplace, the more likely success and the more productivity that workplace can experience. So those are some tips. Another one for employers is if an employee comes to you and say that they're feeling pressured and upset about workplace dialogue or discussions, don't ignore that. I like to tell my employer clients, your first word out of your mouth when somebody lodges the complaint should be, thank you so much for bringing that to my attention, and then take it seriously and look into it and make sure that the dialogue has been just to simply discuss water cooler conversation, but it hasn't gone too far to become religious proselytization or prosecution, or that discussion hasn't gone too far to maybe disenfranchise someone who doesn't share those religious beliefs. But workplace law doesn't prevent you from having spirited discussions, but it doesn't allow for people feeling pressured, or that their rights aren't valued, or to feel like they have to subscribe to a particular point of view in order to have friends in the workplace. So you do have to create those limitations. In closing, let me just say that we are living through some really difficult times. The law in this respect is changing literally on a weekly basis. And so you can count on the Scott Law team to keep giving you these updates. Hopefully next time won't be from the airport because my flight schedules won't have changed. And so we look forward to the continued dialogue. Now, if you're listening in at the live time, don't worry, there are live lawyers right now available at the Scott Law team. So you can send in your questions and we'll be more than happy to answer them. Okay, so this is Cathleen Scott joining you from the airport background in Asheville, here for the Scott Law team. It's been my pleasure today. I hope that's answered some of your questions. Take care and see you later.